Definitions that actually help. These definitions aren't very formal, but they might actually help you understand what you're reading as you try to figure out what's going on with your case. Afterward, you can look into other sources or ask an attorney, but here's a head start. Appeal. A process requesting that a higher court overturn the result of the trial court. Appointed attorney. An attorney who represents defendants that cannot afford an attorney. This can be a public defender or a private attorney appointed by the court if the public defender has a conflict or represents a co-defendant. Arraignment. When the judge reads the formal criminal charge to the defendant. Arrest warrant. A paper that allows the police to arrest and detain an individual based on probable cause that the person has committed a crime. Bail. The temporary release of a criminal defendant before trial. Batson challenge. Objecting to the exclusion of jurors for unlawful discrimination, like race and gender. Bench trial. Trial by judge, no jury. Best interest plea. When a defendant maintains his or her innocence but admits that there is sufficient evidence to convict, it is still taken by the court as a guilty plea. Beyond a reasonable doubt. The standard of proof required for a jury to convict a criminal defendant. Bond. Property pledged to the court for the release of a defendant. Bond reduction hearing. A hearing where the defendant tries to show the judge that he or she has ties to the community, cannot make the current bail amount, and/or is likely to appear for all court dates. Bond revocation hearing. A hearing where the prosecution tries to show the judge that the defendant should be taken into custody for receiving new charges or failing to appear for court. Burden of proof. The party that must prove its case, usually the prosecution. Cash bond. The full amount of the bond required, paid in cash, to release a defendant from jail. See surety bond. Character evidence. Trying to show that a defendant or victim has a certain character trait and probably acted the same way on a different occasion. Example: the defendant has a hot temper and therefore probably started the fight. This argument is only allowed in some situations. Charge. A formal accusation made by a governmental authority that somebody has committed a crime. Charging document. The piece of paper with the accusation, such as an affidavit of complaint, criminal information, indictment, citation, or traffic ticket. Civil case. A case where a citizen, plaintiff, sues another citizen or business, defendant. If the plaintiff wins, the defendant must pay money. Criminal case. A case where a state or federal government entity, prosecution, sues a citizen, defendant. If the prosecution wins, the defendant may go to jail. Co-defendant, also called a charge partner. When multiple persons are charged in the same case. Community corrections. Alternative sentencing. House arrest. Concurrent sentencing. At the same time. Consecutive sentencing. One after the other. Consent. when a defendant allows the police to conduct a search which excuses the requirement of probable cause. Custody. A defendant is in police custody if a reasonable person would not have felt free to leave. Defendant. The person charged with committing a crime. Discovery. Evidence that the prosecution intends to use against the defendant. Diversion. A program where a defendant can avoid jail time and have his or her record cleared after meeting certain requirements. Due process. Sufficient notice of the charges, the right to have a fair decision maker, and the right to present testimony and evidence. Extradition. When one government entity transfers a defendant to another entity, example, sent from Tennessee to Texas. Evidence. Oral or written statements, exhibits, physical objects, and various documents presented during a trial. Evidentiary hearing. Any hearing where the judge rules upon admissibility of evidence, example, suppression hearing. Exclusionary rule. Prevents evidence that was unlawfully seized from being admitted into evidence. Exculpatory. Evidence that favors the defendant in a trial. Expert witness. A witness with specialized knowledge, skill, experience, training, or education whose testimony may assist the judge or jury to determine contested facts in the case. Felony. A sentence of 1 year or more of possible imprisonment. Fifth Amendment. The right to a grand jury, to avoid double jeopardy, to avoid self-incrimination, and to due process of law. Fine. Money that is assessed against you by the judge or by negotiation. Drug and DUI cases often have minimum fines written into the law. A fine is different than court costs. Fourth Amendment. The right against unreasonable searches and seizures. Hearing. A presentation of evidence or legal argument before the judge. Hearsay. An out-of-court statement used to prove the truth of the statement. Example, an invoice by a mechanic to prove the amount of damage to a car when the mechanic is not present to testify. Hostile witness. When a witness surprises the lawyer who called them and will not cooperate. Being declared hostile means that the lawyer can ask leading questions to limit the testimony of the witness. Hung jury. A jury that cannot reach a unanimous verdict. This usually results in a new trial. Impeaching a witness. Showing that the witness should not be believed due to bias, prejudice, a previous criminal conviction, or because the witness said something different previously. Inculpatory. Evidence that tends toward the defendant's guilt in a trial. Indictment. See charging document. Jail. The local holding facility before a person is convicted. See prison. Judge. The finder of facts in a bench trial and the decider of issues of law in a jury trial. Jurisdiction. The court's authority to hear and rule upon a case. Lay witness. A witness that is not testifying as an expert. Misdemeanor. A sentence of less than 1 year of possible imprisonment. Mistrial. When a trial is canceled before a verdict has been returned, often due to improperly admitted evidence, juror misconduct, or a hung jury. The court can hold a retrial when this occurs. Motion. A paper asking the court to take a specific action. Examples: suppress evidence, amend the indictment, etc. Negotiated agreement. Also called a plea agreement. When your attorney and the prosecution agree on a charge and penalty rather than going to trial. Nolle, prosequi. When a case is dismissed but can be brought back upon certain conditions. Preliminary hearing. A hearing to determine whether there is enough evidence to require a trial, also called a probable cause hearing. Pretrial hearing. A hearing on an issue that must be decided before the trial. Example: whether certain kinds of evidence will be admitted at the trial. Prison. Where a person is sent after conviction by the State Department of Correction. See jail. Probable cause. Where the facts and circumstances within the officer's knowledge with reasonably trustworthy information are sufficient to believe that a crime is being committed. This is the standard required for a warrant, for making an arrest, or to search property. Probable cause hearing. See preliminary hearing. Probation. A suspended sentence, avoiding incarceration but still having to meet certain requirements. Defendant. A defendant that is representing himself or herself without an attorney. He or she will be held to the same standard as if they have an attorney. Prosecutor. The attorney representing the government, seeking conviction of the defendant. Public defender. See appointed attorney. Reasonable suspicion. A rational inference related to a particular individual based on specific facts. The suspicion must be more than a hunch, but less than probable cause. This is the standard to frisk a person for weapons. Reciprocal discovery. Evidence that the defendant intends to use against the prosecution. Release eligibility date. The first chance that you have to be released from prison. Depending on the length of the sentence, you may be released automatically or have to go before the parole board. Restitution. Money that must be paid to reimburse the victim for loss or physical property. Search. A search occurs when a reasonable expectation of privacy is infringed. Search warrant. A court order that allows law enforcement to conduct a search for evidence. Seizure. Meaningful interference with a person's property. Sentencing hearing. When the judge decides the penalty for a defendant who pleaded guilty or was found guilty. The defendant may testify, but is not required to do so. Other character witnesses may also testify. Sex offender. A person who has committed a sex crime. Example: rape, sexual battery, indecent exposure. Sixth Amendment. The right to a speedy and public trial, an impartial jury, to be notified of the charges, to confront witnesses, to call favorable witnesses, and to have assistance of counsel. Statute. A state law. Example: aggravated assault is TCA 39-13-102. Suppression hearing. When the judge decides whether evidence unlawfully seized should not be admissible during the trial. Surety bond, also called a corporate bond. An agreement between a person and a bondsman where the bondsman posts a bond so the defendant can be released from jail. See cash bond. Testimony. Oral or written evidence given by a witness after being sworn and under penalty of perjury. Time served offer. Although you are pleading guilty, the case is settled based on the jail time that you have previously served, so none more is need unless you violate probation. Verdict. The finding of fact